any contribution paid by the employer, any contribution is paid by the employer is also not included. If the employee is included, employer payment is not included under wages or for the benefit of workmen under any law by the time being forced. This is also not included. And the third one is any gratuity payable on the termination of his service is also not included. If an employee is terminating, but is also not including under wage. So this is a very important section 2 subsection R definition of wages. So public utility services. So public utility services also they define in this act any railway service, transportation service for the carriage of passengers, goods by air. Any services in connected with working of any major port and dock. So these are also all considered public utility services as per section 2 subsection N in Industrial Dispute Act 1947. Then the objective of ID Act is very clear. Here to provide good environment to the industry to survive. The unique object of this act to provide collective bargaining to maintain peaceful atmosphere in the industry by avoiding illegal strikes and illegal lockouts. So illegal strike is a weapon of wage workers and employer is lockout. So both are avoiding. Right? This is the major motto or objective of ID Act. So here the ID Act also how the issues can be redressal and various. What is the mechanism? The first mechanism is works committee, where the industry establishment are more than 100 workmen is working under any working day preceding last 12 months need to appoint one works committee officer. Appropriate government may require to appoint works committee as per section 3 subsection 2. Cancellation is also appointed. Cancellation also appointed by this. Appropriate government, maybe central and state government, may empower to appoint a cancellation officer if any identified any in case of any public utility services matter and strikes and lockouts, the cancellation officer to initiate, reconcile the proceeding to try to settle the issues. And board of cancellation officer, if the cancellation officer is not redress the issue, then the board of cancellation is also appointed through the appropriate government through issue a separate gazette. To issue a separate gazette, the appropriate government may appoint board of cancellation. So it consists of chairman, 2 or 4 members to discuss the issue and redress this whatever the disputes are there. So the board will also entitle reason account of which it is opinion settled would not arrive at this recommendation determined period. Then the issues will not solve. Again, the court of inquiry. The court of in the occasion the government can initiate court of inquiry. So here the court of inquiry is also initiate to redress the issue. The appropriate government appointed this court of inquiry. Then again, the issue is not solved. Then labor court is also there. The labor court should import the constitution one or more labor courts adjudication of these industrial disputes relating to any matter specified second schedule and performing such other functions may be decided here. So like appropriate government is also appointed. So who is this court judge is equivalent to high court judge and minimum 3 years of experience, to inquire this issue. And if it is redressal is okay, then it go for tribunal. So through issue the appropriate government may issue a separate through its gazette and constitute industrial tribunal adjudication industrial dispute relating to any matters. The matter can be either wage, hours, promotion, or relocate of the industry. Various issues are also there. So appropriate government can also initiate to industrial tribunal to solve this issue. Then If it is not possible, then the national level, the central government is alone to be empowered to constitute one or more national tribunals to adjudication of industrial disputes. So this is the highest body regarding industrial disputes under mechanism is highest body. The issues may be involved questions of national importance, right? National importance are such as a nature that industrial establishment situated more than one state to one or two more states, the central government has initiated to establish a national tribunal as per this Act, Industrial Disputes Act 1947. Right? Then after this, the notice are be discharged, given the notice to this as employers. And then after this, we understand the procedural powers of duties of authorities. Whatever the authorities, either labor court, conciliation officer, or tribunal or national tribunal, they have a timelines are given. Based on the timeline, they need to submit the report to appropriate government. At the same time, award nothing but giving the judgments. As the court give the judgment, labor court or tribunal or national tribunal, they give this judgment. And this is called as a award as per section 2, section 16, subsection 2. Then after this, we'll go to this. What is meant by strike? What is the definition of the strike? What is a lockout here? Right? What are different types of strikes also there? Right? Strike. The strike is defined under section 2, subsection Q of Industrial Dispute Act. Is the cessation of work by a body or persons employed in any industry acting in combination of or a concerned refusal under common undertaking any person refusal working, right? So they're attending the office but they won't work. They're attending the factory, they are not working. So it is one kind of strike. And one more thing is the strikes can be hunger strikes, economic strikes, stay in strike, go slow strike, sympathetic strike, right? There are various strikes are there. No, hunger strikes mean they won't take meal, or economic strike mean they want for higher wage payment or promotion something. Stay in strike, they are staying in the factory but they won't work, right? This is called as stay in work. And go slow, so they are working but they are not meeting this whatever these targets. Right. Sympathetic was strike nothing but suppose some other union, some other members are going for strike, and these people also showing the sympathetic strike, they are also not participating in this workforce. So, like the procedure for strike, the procedure strike nothing but starting giving the appropriate notice to the management. So, according to section 2, section 22nd, subsection 1, no person employed in a public utility service shall go on strike in breach of contract. So as government mentioned, some of the department they won't go for strikes. Like the government always saying that using we imposing ESMA, right? Even RTC, when RTC go for strike more than 1 month, so the KCR government say that we are imposing ESMA essential act. Mean the management has the right to terminate the employees, right? And see that this is also case, but public utility is not possible without giving a to the employer notice to the strike. Herein, after avoiding within 6 weeks before going to strikes means before 6 months means 45 days before they need the workers, they need to give the notice to this employer. Within 14 days giving such notice. After giving such notice, they need to go for strike. Lockout. So lockout is also defined in the service in the section 2 subsection 1. So lockout means the temporary closing of a place of employment or suspension of work or refusal by employer to continue the employee any number of persons employed. So like they are given here. So this is the weapon of management they can go for. So temporary closing of place. They employ labor's wages are workers are not allowed in the factory. They close temporarily. The suspended of work. And these are the definition given in Industrial Dispute Act 1947, Section 2, Subsection 1. So procedure is like strikes. The workers are given this notice. Here also, the employer has given the notice to these workers, right? So no employer carry any public utility. So like no, they also without giving them notice to the lockout as therein after provided within 6 weeks before going to lockout. So as management, they need to give first 6 weeks before, nothing but 45 days. Within 14 days of the given notice, they are also given same. So like this is a weapon of management, that is a weapon of strike is a weapon of workers. So significance of 14 days within 6 weeks. 14 days within 6 weeks, they go for either strike or lockouts. So here general strikes and lockouts. So here they mentioned section. Sometimes there is a cancellation process going on, or board of cancellation office also appointed. Such times, the both parties may go for strike or lockout. So this is one. The second one is pendency in the proceeding before labor courts, tribunal, national tribunal, and 2 months after cancellation such process. So any issue with the pending in this uh, either labor courts, tribunal or national tribunals. So these management or wage workers, they won't use this weapon like strikes and lockouts. So during the pendency attribution process, before attribute officer also appointed, these situations they won't go for strikes. So illegal strikes and lockouts. So in this section clearly mentioned how to wait a minute. Right, illegal strikes. It is commended or declared in a controversies of section 22nd or section 23. It also mentioned illegal strikes. Illegal strikes where a strike or lockouts in presence of an industrial dispute has already commenced is in exercise at the time of the therefore, like they declared here. So justification and justified and justified strikes also there. So we have witnessed so many strikes and cases also. Even some Supreme Court also giving these judgments regarding this courts, Bank of India and versus TS Kelwada in 1990s. So justification of lockout and wages of payment of period also mentioned here. So like this is a very important uh, acts regarding these labor laws. Like every employee, they know their rights and duties, right? Then this one more thing is layoff and retrenchment. Layoff, what is meaning of layoff? As per this section, IDs Act is clearly mentioned. A layoff described the act an employer suspending or terminating a worker either temporarily or permanently for a reason other than the employee actual performance. So here layoff means the employer can remove these workers either temporarily or permanently. He can remove for his actual performance. So layoff may be happened to displaced worker those job has been eliminated because of employee has like various issues are there. So layoff would be considered without any authority law such established. So industrial establishment in which less than 50 workers employed on an average workday. Industrial establishments which are a seasonal character or in which work is performed only for intermittently. Sometimes seasonal works, right? Some industries are there, they work in a seasonal base. Like we know the sugar industry. If the sugar industry employ sugar company cannot provide the whole year of employment. So wherever the season is there, they can recruit. Then after this period, they are removing. So it is called one time of layoff. So seasonal base, that is called a seasonal characteristics. And employees employed in above establishment do not have the rights laid off compensation also. So here some of these mentioned the right of workmen layoff for compensation also. If they provide compensation, they can also remove. So then retrenchment also mentioned in the Act, Section 2, subsection OO. Retrenchment means the termination by the employer of the service of workmen for any reason, whatever. Otherwise, then the punishment implement, they also voluntary retrenchment, all also given here. So after this, we'll go to this one more acts under we are in block 3. So block 3 in our syllabus, at block 3 we have a four separate acts are there. Payment of Wage Act 1936, and ninth one is unit number 9, Minimum Wage Act 1948, Payment of Bonus Act 1965, Equal Remuneration Act 1976. So these four acts we are going to discuss in block number 3. So let's start with our block 3 first unit, that is 8th unit, Payment of Wages Act 1936. So it is the British period, the act is enacted all over India except Jammu and Kashmir. So these acts we discussed what is the need for this act, object, scope of and applicability of this act, and fixation of wage period, time for wage payments, mode of payments, deduction of wages, and maintenance register and record, obligation of employer under this act also we are going to discuss. So this act is enacted, Act 1336 is enforced on 23rd April 1936. So this act was passed to regulate what is purpose of this act. So any act is passed, first we need to understand what is the purpose, right? Why this act is enacted. The act was passed to regulate payment of wages for certain classes of persons employed in industry to ensure payment of wages in a particular form, and it regulate intervals without any unauthorized deductions, right? So here it is clearly mentioned. Here regulate this payment of wages, right? How frequently they are paying the wages, and also see that deductions, intervals and deductions, right? Wages are the return payment by the employer where the work is done on an organization. So even the Constitution of India has also framed various laws regarding to settle the provisions for safeguard of employees for injustice causes, injustice cause also. Right? Need for this act. So where the government within this, with the growth of industries in India, the problem related to payment of wages, right? Various kind of industries are there, and there is no uniformity of payment of wages. There is no uniformity in the payment of intervals of wages, right? And there is various issues are there to not giving the proper wage payment to these workers. So a good number of industries units were make the payment their worker regular interval wages were not uniform. If they paid regularly, but there is no uniformity of payment of wages, then with the hold of the payment of wages, affect unreasonable deductions also there. Unreasonable deductions, right? What is the percentage you can deduct? The company cannot deduct this, right? If the employee getting 20,000 salary, the management cannot deduct more than 10,000 rupees as deductions. Like they will show that insurance for PF or something reasons that they won't deduct, right? They have to, some legalized deductions are there as per this act. The imposing unwanted fines also. The company, management cannot impose the fine also, and so on. Employer could. could do it because either there was any legal provisions or restrictions all that mentioned. To address these issues, in 1926, Government of India asked the local governments with the view of certain provisions with regard to the delay in which occurring the payment of wages. So, like this is the background of why this act is also enacted. And this act finally is 1936 Act. 22nd March was enforced, and April is also applicable all over India. So, aim and objective of this act, minimum Wages Act 1936. So, the main objective of this act is to ensure and promote a prompt payment of wages and to prevent unauthorized deductions and arbitrary fines from wages, right? The, the earned wages of employed persons shall be paid. There should be timely and regular payment of wages. The Act prohibits deductions. Let's first start with one by one. The earned wages of employees shall be paid. So whatever he worked, he has to right to get this wages. He has to work at 8 hours or 9 hours or 1 month, 2 months, 10 months. So like they have to mention. So here in this act say that there should be a timeline regarding the payment of wages. There should be timeline is important to payment of wages. Suppose if you employee work in uh, so if employee working within the organization like uh, January month, 1st January to Jan 1st to 31st Jan, his work, he will get the payment within 7 days. Means before 7th of February, he has to get. If the employees are more than 1,000, if the employees are more than, if the employees are less than 1,000, he or she will get the wages before 7th of next month. If employees are, if these workers or employees are more than 1,000, so they will get before 10th of next month. So that is the timeline mentioned in this act. Am I clear? Any doubts, sir? Any doubts? Hello? Hello? Mehboob Garu, please respond. Hello? Hello? Mehboob Garu, like the time is mentioned, the act prohibits reductions. The act is prohibition reductions of wages that are unlawful to regulate the amount of fine that can be imposed. If any factory or any company then can impose, they need to fine it. So certain percent, 15% cannot be imposed more than deductions. The act declares controlling out as null and void, whereby an employed person given up right conferred by him this act. So act does not apply the person whose wage exceed 1,500, 1,600, right? The act does not apply to person whose wages exceed 1,600 per month. Is not right. Is a previously, but now in the August 28, 2017, the revised payments. So before it is only the 18,000 per month is there. Now increased to 24 per month. So those employees, those workers are working in the month, their salary is before below 20,000. This act is applicable. More than that is not is applicable. So as every 5 years, like based on the central government and NSSO, National Samples Organization, they also based on the consumption, based on this expenditure, they will decide minimum wage. Now the minimum wage is 24,000 per month in 2017 onwards. Am I clear? Covering a significant large number of employees within the purview of this act. So this act is applicable whole India. This act applicable whole India. The applicability, the person employed in any factory A person employed other than the factory is also applicable. A person employed upon any railway administration, or by a person fulfilling a contract within railway administration is also applicable. A person employed in a industrial or either other establishment also applicable. A person whose wage is less than, previously is less than 18,000, now it is revised to, it is enhanced to 24,000 per month. It is applicable, right? So here is also defined who is this uh, act is applicable to the employees. What is employment? Employed. So employed is also given here. Employer, it includes legal representation by a decrease in law. The fact is also mentioned. So even in Factories Act 1947, it clearly mentioned earlier we talked about Section 2 is a clearly mentioned what is factory, right? Earlier, right? And industries means industries include as per this Act, subsection 2, section 2, subsection 2, and termway or motor in all transportations also included, and jetty, right, duck is also wherever the exports or imports are taken place is also covered here. Inland vessels is also included. Oil refineries, plantation is also included, and wages also defined here as per this acts. Wages is covered. Remuneration payment of under any award settlement between parties is as per this, right? But as earlier told you, the bonus is not included here, right? Minimum wage is not included. Bonus. The value of house account is also not included. And pension provident fund contribution by the employer is not included. Not included. Travel allowance, travel expenses is also not included. So responsibility for payment of wages. Who is the responsible payment of wages? Like establishment has a responsible payment of wages. Who is the so like the factories, if a person has been named the manager of the factory, he has a responsible person to pay to make the payment of minimum wage. The industries of other establishment, if there is a person responsible for employer, supervision, controller of other is also responsible. Upon railways, if the employer, railway administration has to authority to make the payment of minimum wage. The person so named, the person responsible for employer, the person nominated any case also responsible for payment of wages. So fixation period, the person responsible for act, the payment of wage act shall be fixed as per this appropriate time. The time for wage period, as earlier talked about, if less than 1,000 within 7 days, if the more than 1,000, right, within 10 days. So January month salary, he or she will get 10th of February month. Expire before that, first or second also will get. If more than that, is not allowed as per this act. In case of person employed like jetty, work mine, work, so they will be get 7 days before completing. Within 7 days they will get, right? And sometime where the employment of person terminated by or her behalf of employees, the wages can be paid at second working day. So if the company terminating, they need to pay second day. So mode of payment is also cleared here. Section 6 Act, Section 6 of Wages Act, all wages shall be paid in currency notes, currency coins, or both. Nowadays is they paid in this through NIFT or bank account they are paid, right? And here deductions allowed. Like if the illegal deductions are there, so the fines can be imposed, right? So employee person can be fined only the act and omission which can be specified. Like no, these are only allowed if the more than that it can be allowed punished. Absence from duty, the ratio between the amount of such deductions is also covered. Damage of losses or accommodation providing service also covered here. And the limit of the amount of deductions. See, the deductions, the whole or partly made for payment cooperative societies exceed 75%. So cooperative societies cannot be exceed 75% of wage. Other these case 50% of wages is not exceeded, right? More than 50% is not exceeded. So they need to maintain the proper records regarding this person's employed, what is the work performed, wage payments, any advances also declared, deductions made from wages. So receipts given. So obligations of the employer under this to fix wage period not exceeding one period, 1 month, as per section 5. So not exceed 1 month. So January month you will get before 28th of February, right? So that is maximum 1 month. To afford facility to inspector to entry, inspection, supervision, examination, or any other. So like these are the mentions are mentioned. Inspe Authorized their duties and powered up. Procedure also mentioned. Inspector also there. Authorities also there. And direct district court appeals also there. So any disputes are there regarding this, they also meet. Like here, the offenses and penalties also there. If the delay in non-payment of wages within prescribed time by whoever is responsible payment is, fine is minimum 1,500, the maximum is 7,500. So as per this act is also mentioned the penalties, right? So here the same. So whoever the makes any deductions in contravention of this act or imposes fine, so same amount is also available. 7,000 maximum is 7,500, minimum is 1,500 as per this act. Penalty is also imposed. So here see that miscellaneous provisions as per this act. There is various provisions are there regarding this payments. So methods for computation and fixation of wages. So like how to fix the wages. Uh, Various methods are there. So here it is one method, monthly wages are fixing. For calculating the salary, calculate the salary always calculate the month or complete month. Means if you join in the month of February, 15th of February, the month will end 15th, 28th of February. So it is complete month. It's not 1 month. So it is 15 days. So start work after first day for the month. The leaves of employee before last working month. So like this is a formula for using this monthly wages. So daily wages. So here calculating week wise 12 months into monthly basic rate at 52 weeks average. This formula are applied for this calculating daily wages. So this whole we covered so far two acts, that is Industrial Disputes Act 1947, and one more thing is we covered so far the Minimum Wages Act 1932, 1936. These two acts very important to as an employer, as employee, we need to understand our duties, right? And the next block in our topic is tomorrow we are going to discuss. The next one is Minimum Wage Act 1948. So there is a difference between, right? The Minimum Wage Act is Payment of Wages Act, that is. So Minimum Wages Act 1948, after disputes, after this Industrial Dispute Act, have a new act, that is Minimum Wages Act 1948. So this act is also central legislative aim to statutory fixation of minimum wages of employment where seated labor is prevailing possibility, right? This is also mentioned here. So tomorrow we are going to discuss this Minimum Wages Act 1948. Any doubt? Mehboob? 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 Hello? Hello? So tomorrow we are going to discuss again two acts are there. That is the Minimum Wages Act and one more act, two acts we are going to discuss tomorrow. And we complete this block 3 as early as possible, Minimum Wage Act 1948. And we are going, after this, we'll going to discuss one more act, that is called Payment of Bonus Act 1965. So this, whatever this block 3 purely mentioned the honorarium or benefits of these employees, their rights and duties. Right? Tomorrow we are going to discuss Minimum Payment Wage Act 1948 and Payment of Bonus Act 1965. So which employee has to get the bonus, right? So that part we are going to discuss tomorrow. Now I will stop here, and if you have any doubts, please uh, discuss tomorrow, right? Thank you so much.